Good afternoon, everybody. My name is Stephen McEwan. I'm a partner in the insurance team at Hogan Lovells, which is an international law firm. I'm delighted to have been invited here today to give a talk to you on the legal and regulatory implications of Brexit for the insurance industry. And I'm very grateful to Mervyn and to Paul and Brigitte for setting up my attendance here. I'm grateful to you. I'm also very interested to hear the speech that John's just given, and I'll hope to mention a few things of that as I go through. The focus of my talk is on the legal and regulatory aspects of Brexit and how they are playing out in the United Kingdom. And as I do that, I'm going to be looking at the current status of the legal developments on Brexit, key risks and opportunities that arise from Brexit for the insurance industry, and the implications for different types of entities. So the primary focus in this presentation will be on insurance companies, and that will include Lloyd's of London, and on insurance intermediaries, that is the people who distribute insurance and indeed assist in the performance of insurance contracts. Like many loss adjusters, I am a person who provides services to the insurance industry. I'm part of the legal community, and we are a professional body as well, which provides services. And so I'm thinking of it from my perspective as a lawyer, in much the same way as you'll be thinking of it from your perspectives as loss adjusters, in that we provide services to this large industry, which is the insurance industry. And that's obviously a subset of the overall financial services industry. So if you now start to include banks and investment firms and funds, all of which are affected in some way and in a large way by Brexit. So I'll look at the regulatory implications for them. There's a couple of poems, so if you do get bored in the course of the conversation, then you can look at these slides. But this is from poetry from a long time ago, which has actually quite a lot of striking features in relation to Brexit. But I'll come now on to some statistics. And there was a recent London Market Group report, and it looked at the statistics for how much business is brought into London from the EU, EU customers, so policyholders and cedents in other EU jurisdictions placing business into London. It was 8 billion of premium a year, and similarly 6 billion of the premium that's written in London is written either by branches or subsidiaries of insurance groups that are headquartered elsewhere in the EU. So a very large interaction of the UK insurance market with the wider EU insurance market. It's also worth noting how big the EEA insurance market is. That if you essentially look at the EEA other than the UK, we have $432 billion US dollars of non-life written premium in the EEA, excluding the UK, and 21% effectively of the global gross written premium. So it's a very large part of the worldwide insurance market that the UK, by cutting itself off, if it does cut itself off through Brexit, will potentially lose access to. We've done some analysis of the different insurance groups and what they've said about their plans to deal with Brexit. We've looked at 27 insurance groups who've made some kind of announcement about what they're going to do. And you see a bar graph there which shows the destinations that they've put forward. So Luxembourg and Ireland are the two that stand out. So both of those have got 10 groups, 10 insurance groups who've said publicly that they are considering moving to those jurisdictions. And then Belgium, France, Germany and Malta have got smaller numbers. It's interesting to note that Lloyd's of London is thinking of Belgium as its destination. But Ireland is certainly a key one, and we've just heard John talk about Ireland. We're seeing that as, if you look at some of the reasons that are given, and John's right, they in many cases do not give reasons, but in many cases insurers who are operating in the UK already have some operations in Ireland, so it's easy to move there to join on to them. It's an English language speaking jurisdiction, which is seen as helpful, and as far as the law is concerned, there is a historic common legal system that unites Ireland and the United Kingdom, and therefore there's a lot of the common law that makes up the insurance law is very similar there. But obviously some insurers have taken a different view, and as I mentioned, Lloyd's of London has chosen Belgium, and it's not entirely clear what all the reasons are in every case. Areas of uncertainty that stand out particularly for the insurance sector, and the one I put on the top of the slide there is the one that you've heard quite a lot about in the insurance market, and that is, will it be legal to pay out claims on a contract that was written prior to Brexit? So if you imagine an EU insurance company and it's set up a branch in the UK, and that branch in the UK has written policies in the UK before the Brexit date, if Brexit has the effect that that insurance company is no longer allowed to do business in the UK unless it gets a separate authorisation, then it will be illegal. It's not just that there'll be a difficulty, it will be illegal for them to pay out claims on those contracts. Because, and the reason for this is, the Financial Services and Markets Act requires that in order to pay out claims on contracts, a legal entity has to be authorised in the United Kingdom to do that. An exception to that is if the entity is passporting under the Insurance Directive, Solvency II, and for so long as we're in the EU entities, insurance companies are able to passport and have their branch here. But the moment we leave, unless there is some other arrangement put in place, it will become illegal for them to pay out the claims. And the Association of British Insurers has been very vocal on this point, as have a number of other bodies, to say it's preposterous if we have a situation where UK customers are not able to receive payment from insurers because it's become illegal for the insurer to pay out, or face a delay and have to force the claim in court. And similarly, the same problem applies in reverse. So if we have UK insurance companies who've set up a branch in France or Germany and are currently allowed to do business there because they're passporting into France and Germany, are allowed to have that branch without going to the French or German regulator and being authorised, well, they will be in the same situation, that for them to pay out a claim following Brexit would be illegal, and therefore they would need to, in order to avoid that, get an authorisation from the French or German regulator. And actually it's a particularly acute problem if the UK insurer has branches in 27 different countries throughout the EU, because each one of those would have to be authorised if they want to carry on as before. But it does lead to a preposterous situation where in all those countries you could have policyholders who perfectly legitimately paid their premium and now can't be paid out a claim. So we need to do something about that problem at the very minimum. And I'm able to say the UK government has said that it's going to fix that problem. So if necessary, it will introduce legislation which makes it legal, notwithstanding the position as it is at the moment, for an EU insurer to pay out claims, notwithstanding it doesn't actually have an authorisation in the UK. So that's a very good development for EU insurers who will be providing contracts of insurance in the UK. But what about the reverse? I mean, currently, as it stands, we would need legislation in all the different countries of the EU individually in order to fix that problem in each one of those countries. So it's a significant issue. A number of other things there on the slides. So communications with policyholders. Will you be allowed to send an advertisement to a policyholder in another jurisdiction? And will you need a new authorisation as a result of Brexit? How quickly can you obtain that? It's quite a lengthy process. In the UK, for example, there is a process where once you've submitted your form for application to have an authorisation, the regulator has 6 months to consider it. And if they consider that your application was incomplete when you submitted it and they want further information, they can extend that to 12 months. So you can imagine that somebody who's coming up now, we're not far away from being 1 year from Brexit date. If somebody wants to get a new company authorised in the UK as their solution for Brexit, then they're already coming close to that 12-month period that it could take in order to have the entity authorised. So it's, time is actually running short. Other solutions might be to have an existing branch authorised. So rather than set up a new insurance company, get the existing branch and have it authorised. And that will be my recommendation as the best solution for insurers, EU insurers who are doing business in the UK currently. But there's still a question of what happens to the old business if you were to set up a new company, and what would you do about the business that's already been written in the existing company? And there are ways of transferring insurance business from one entity to another, but they are also quite cumbersome and take a lot of time. John in his talk mentioned equivalence under Solvency II, and I will go through what equivalence means in the context of the insurance directives and explain how significant that will be. There are two ways in which that's important. One is for the consolidated capital position of an insurance company, and the other is in relation to the provision of reinsurance. Question, will there be a free trade agreement covering insurance? And there's a lot of emphasis, a lot of people saying there should be as part of a wider financial services free trade agreement. but I question, is that really realistic given the political dimension? And some of the proposals will effectively mean that we have Brexit in name only and everything carries on the same. And I just have my doubts about whether that would be something that politically would be acceptable, although it's all speculation. And then there's something called community co-insurance, which I'll talk about briefly. Give you the context of how we stand on a timeline towards the Brexit date. If you look on the slide, we had the referendum in June 2016. In December, we had the report of the UK and EU and UK negotiators. And then we were heading towards March 2019, when the 2-year notice period will expire, and barring some other arrangement, we will leave the EU. Well, there's two very important regulations that will come in before that date. One is the General Data Protection Regulation, and the other is the Insurance Distribution Directive. Both of those will be law that the UK, because it will still be a member state of the EU at that stage, will have to incorporate into its law, and where UK entities will have to abide by that law, notwithstanding that we're at the moment heading towards the exits. The effect of being a member of the EU is binding on us right up to the point when we leave. So any new laws that are coming in before March 2019, at the very least, we will have to implement. We may have a transition period after that, and clearly you've read plenty in the press about a transition period if we can reach agreement on an appropriate withdrawal agreement that creates that transition period. But every expectation is if we have a transition period, then we will have to respect any new EU laws that are made during that period as though we were a member. And that's the quid pro quo. If you want to benefit from the access to the EU markets that being a member of the EU gives you, or being in a transition period with the EU gives you, then you've got to accept the law that comes with that. And finally, if we come to the end of a transition period, we would then be completely out of the EU, but we might have a special agreement with the EU, which gives us a special status with regard to that. And there are such agreements. For example, in relation to non-life insurance, Switzerland currently has an agreement which allows its insurers, even though it's not a member of the EU or the EEA, it allows Swiss non-life insurers to enter into the EU as though they were members of the EU. And possibly we will head towards some kind of agreement like that, or indeed an even closer agreement if we can. But that type of agreement takes a very long time to negotiate, and even a 3-year period, if we manage to get a transition period of 3 years, people I speak to who are involved in negotiating trade agreements like that consider that is not long enough to agree a comprehensive free trade agreement that would of the kind even as good as the Swiss agreement. So quite a lot there. It's also interesting to think about how binding is anything that's being done going to be. You'll have seen in the press that we had the report at the beginning of December, the report of the UK and UK negotiators. And the very next day, the UK politicians were saying, oh, well, that's not really binding. And we had a lot of the discussion about, well, what about the effect on the border between Ireland and the UK? Now, actually, if you look at the text of the report, those politicians who said it wasn't binding are actually correct, because I've put the text on the slide, that it was agreed by the UK on condition of an overall agreement on the UK's withdrawal, including an agreement as early as possible in 2018 on transitional arrangements. So actually what they agreed in December was all subject to a further agreement in 2018. And so essentially we're building on conditional agreements towards hopefully an agreement that does get put in place which gives us a transition period, and that's going to be called the Withdrawal Agreement, and we'll set in place, we hope, some sort of 2 to 3 year period where everything stays the same until we can work out something better for the long term. But at the moment that's all conditional on something in the future being agreed, and it could, in a really worst case scenario, completely collapse because nothing that's been agreed so far is in fact binding because of that condition that was included. So in what is the context in which we're talking? Well, we talked about the Article 50 notice quite a lot already today, and I thought it'd be useful to look at this precise text of Article 50, which is from the Treaty on the European Union. And you can see that Article 50 paragraph 2 says that if a state decides to withdraw, it notifies the Council, so that was the Article 50 notice. And then there is a period during which we try to reach arrangements for the withdrawal, and this text here, acting by a qualified majority of the Council. So the UK and a qualified majority of the EU countries can reach agreement on the withdrawal agreement. We do also need the consent of the European Parliament, so their voice will be strong in any kind of agreement that gets put in place. But a qualified majority plus the European Parliament is at least a realistic target. You think you could get a qualified majority of the other EU countries plus the European Parliament, we might be able to get something through. Contrast that though with the situation where you need unanimous consent of all of the other EU countries, including in some cases multiple parliaments within those countries. And Belgium has 7 different entities within Belgium who have to approve anything. So if we want a new treaty with the EU as opposed to a withdrawal agreement, that will be very much harder to agree and put in place because of the requirement for wide consent of everyone. Whereas the withdrawal agreement is something that is realistic. And it emphasises how important it is that anything we want to stick, anything that we really want to last beyond March 2019 has to be in that withdrawal agreement. Otherwise, we're going to be negotiating with the EU and every single member of the EU, which, I mean, as we saw when the previous Prime Minister attempted to go around Europe and find ways to compromise, it is extremely difficult to reach compromises on. If we don't reach an agreement, then Article 50 will have the effect that we leave 2 years after the notification, whether or not we've got that withdrawal agreement in place. So if the withdrawal agreement is not in place by then we will leave, and then we're into negotiating the new free trade agreement or the new quasi-membership of the EU, which will be an extremely difficult thing to do because of the need for everyone to consent. There is an ability to extend the 2-year period so that we can continue to work on that withdrawal agreement. However, that requires the European Council, in agreement with the member state concerned, unanimously decides to extend the period. So, and again, we're back to every country in the EU would have to agree to extend the 2-year period. And you can imagine it just takes one of them, therefore, to veto it, and we don't get an extension. So it does, I think, underline the importance of this 2-year period and getting something in the withdrawal agreement. Even if it's not perfect, and it still leaves something that we hope could have been included but wasn't. If we don't have that agreement, we're crashing out, and anything after that does require unanimity. EEA agreement's interesting as well. The EEA consists of the EU plus Norway, Liechtenstein and Iceland. It doesn't include Switzerland, but those other 3 countries are bolted on to the EU through the EEA agreement. And interestingly, the UK is a party to that in its own right, and there's a 1-year notice period to exit from the EEA agreement, and we haven't given that yet. So it will be interesting to see in a month's time whether we give that notice. I very much hope, as a lawyer, that for good order we do give it, rather than just thinking it doesn't matter, because it's a bit messy if we are still technically a party to the EEA agreement. But if anyone's got any questions about the EEA, I'll talk about that. Similarly, if anyone has any questions about Gibraltar, I'll be happy to talk that too. I'll say briefly that the EU, the Court of Justice of the European Union, which is the top court in the European Union, has said that Gibraltar and the UK are one member state for purposes of the EU legislation. So when the UK leaves, Gibraltar leaves as well. They can't cling on or stay in the EU when the UK leaves, which is quite significant, because as I'm sure everyone listening knows, that in the non-life insurance industry, Gibraltar has quite a lot of business and is very closely connected to the UK. And we can take questions on Gibraltar later. How is the UK actually dealing with this from a legislative perspective? How are we doing it in terms of our law? The answer is we have the European Union Withdrawal Bill, which would become, if it goes successfully through Parliament, the European Union Withdrawal Act. And this will be a statute of primary legislation which will first of all repeal the European Communities Act 1972, which was the original legislation which brought us into the EU in the first place, gave authority to the United Kingdom to be a member of the EU and to have the laws of the EU have effect in the UK as though they were laws of the UK. We're then going to say that any UK laws that were made because of directives of the EU are also going to be valid and continue to be valid UK laws. And then clause 3, any directly applicable laws, and for example Solvency II is an example of a directly applicable law, as is the General Data Protection Regulation, or when it comes into effect in May. These are directly applicable laws. We will say that they are crystallised into our law as though they were the law of the UK as at the Brexit date. After that, we can still amend them, and because they will be treated as UK law, we're free to amend them after that. But at that particular moment in time, they will be crystallised into our law, which is part of the government's policy that nothing really changes at that moment when we leave the EU, because we keep the same laws that we had before, even if they are currently European laws that directly apply in the UK. And so that is essentially an important point as regards thinking about, well, will anything change the next day? Well, strictly speaking, it won't, and the government's policy and this European Union withdrawal bill is all designed to ensure that nothing does change from a legal perspective. But it can only do so much. What it can't do is give UK insurers any of the same powers that they would have had to do business in other EU member states, because the UK law and the powers of the UK Parliament are limited to the UK. So we can fix any problems that apply in the UK, but we can't fix them outside. That requires a political agreement, and that's again goes back to the withdrawal bill, the withdrawal agreement that has to be negotiated. I'll talk about that withdrawal agreement because it's been a considerable focus. If we look at clause 9 of the bill, this purports to give, and this was the one that got a lot of attention in December because the government actually lost a debate on this, which doesn't normally happen. The government doesn't normally lose debates about Acts of Parliament. But it did lose this one on clause 9 because what it wanted to do was to include a provision that said that the ministers could make any laws they wanted in which they thought were appropriate in order to implement a withdrawal agreement. Now this reflects how important that withdrawal agreement is, so which I was saying a few minutes ago, because they wanted therefore to do whatever they needed to fix our law so that they could validly enter into the withdrawal agreement and make it work. However, there are people who think that's too much power to give to the government because it wasn't going to require sufficient parliamentary scrutiny, and that's why the government lost a debate on that point. And I'll show you what happened to that. It's been amended so that they're only able to make those laws to fix our law in order to make the withdrawal agreement work, subject to and you see the words in red that are underlined. That's the new text that got put in because the government lost the debate. Subject to the prior enactment of a statute by Parliament approving the terms of the withdrawal. So that means that before anything can be done by the government using this power, they're going to have Parliament as a whole approve the withdrawal agreement, which will definitely slow them down in terms of when they can start bringing those things in. It's a highly political point. The other thing that they've changed since they originally brought it forward is this definition of exit day. Previously, they were going to have the power to nominate what day they thought would be appropriate for different laws to stop being effective, which would mean that they could have kept some things in effect for longer. And in fact, now they've said, no, we're going to make it one day, 29th of March 2019 at 11 p.m, which clearly is 12 midnight in the Europe, which is why 11 p.m. has been chosen. But it's quite significant that we've now hard-coded that into the bill that will eventually become the Act of Parliament. And to put that in some context, this is the Solvency II regulatory framework. We've got a directive, and then underneath that we've got a regulation, and then some Yopo guidelines. And as the way that the European Union withdrawal bill will work, in the case of the directive, we've made some laws as part of UK law already, and those laws will remain in force because they were made on the basis of the directive. In the case of the Solvency II regulation, that has direct effect in the UK. The UK never passed that as a law. We never passed an Act of Parliament saying that is our law. That's automatically effective because the EU has made it law. And in that case, that's the one we're going to crystallise. We're going to say that's our law as at the date of Brexit. But we will correct it. There will be some deficiencies in that, and the UK government will have the power to make statutory instruments which correct deficiencies. There's quite a big debate about, well, what is actually a deficiency? Is it just anything the government doesn't like? Well, they've narrowed that definition down slightly to try and avoid that argument. I want to talk about passporting. there's two ways as part of the law in which an insurance company or an intermediary is able to passport. What this means is that you can establish a branch in another country of the EU, and have that branch carry on insurance business or insurance distribution without having a separate authorization in that member state. It's a relatively straightforward process. You notify the regulator that's what you want to do, and you're allowed to do it. And the reason you are is because your home member state has authorised you to be an insurer in your home member state. Therefore, you're allowed to do the same thing in any other member state of the European Union, or indeed the EEA, the 3 extra states as well. And that's what allows us to have that access to the market. And I would distinguish between setting up a branch, which is called the freedom of establishment, having people there permanently and running a business on your behalf in that country, and freedom of services, which is where you stay in your home country, but you do business across border. So you maybe send people across the border to do some business and then they come back again. And this came through in John's speech about the need to have people who are freely able to move across borders and provide services and then come back. We're not just talking about necessarily having another branch in Paris where people are able to sit there to work there permanently on your behalf. And these two different types of establishment of passporting have been in the law ever since we had the directives on insurance, and are therefore integral now to the business of many insurers and insurance intermediaries who work throughout the European Union. The effect of, as I mentioned about 20 minutes ago, the effect of Brexit will be that we won't be a member state of the EU anymore, and indeed will be the effect that, and therefore that insurers who have the authorisation in the UK will not be able to rely on that to go into other countries in Europe and establish a branch or provide cross-border services. It will in fact become illegal for them to do that unless they get an authorisation in the relevant countries where they were providing those services or having the branch. So what could they do about that? Well, they could have the branch they've got already authorised. And there's two things with that. Firstly, that's a difficult process, but it is an achievable one. But it will take time and resource. The second thing is that they might have branches in all 27 other countries of the EU, and indeed the 3 EEA countries as well, which is a total of possibly 30 branches. And crucially, if you get your branch authorised in one of those countries, it does not get passporting rights. You only get passporting rights if the legal entity as a whole is in that country and is authorised in that country and in the EU, and then it can have passporting rights to other countries. So I'm going to flick on now to a later slide where I'm going to show this distinction. I will come back to some of those slides. But if you see on the right-hand side of the slide, you have a UK insurer. It's able to passport, so I show that by the green arrows, into Germany and into France from the UK head office. Once the UK is out of the EU, out of the EEA, it will no longer be able to passport. It can still have a branch in Germany and France, but it will need to get it separately authorised in Germany and in France. So that's 2 authorisations it will have to make. Now contrast this with another approach. Supposing it sets up a subsidiary company in Germany. Now the German company will still have to get another authorisation in the United Kingdom if it wants to come into the UK, because it won't be able to passport into the UK anymore because we will be outside the EU. However, it will be able to passport into France. So there's only one extra authorisation needed, whereas it can passport into France without requiring a further authorisation. So that will be a better method for an EU insurer to adopt, because, well, for a UK insurer to adopt, because by getting one extra authorisation in Germany, it will be able to passport throughout the EU. And I'm going to go back now to look at the options that there are for, firstly for EEA insurers who are currently operating in the UK, and then for UK insurers currently operating in the EEA. So we take first the outside Europe insurers who are working in the UK, who may have a branch already here, therefore using passporting. What can they do? Well, option 1, get the branch authorised, because then with the same legal entity, they are able to have the business in the head office, say in France or Germany, and then have the UK branch. So for one more authorisation, they can carry on doing their business in the UK and similarly carry on all the passporting throughout the EU. By contrast, if they took option 3 there, establish a new UK subsidiary and then have that authorised, they've got two issues. Firstly, they need to move capital into the new subsidiary, and that's expensive because you're now capitalising a separate legal entity. And secondly, it's necessary then to do something about the business that's already been written through the branch that's in the UK already. So the effect of that will mean you need to do some kind of transfer of business, which is an expensive and time-consuming step. So we think for EEA insurers who are currently operating through passporting in the UK, best option will be get the branch authorised. However, PRA has said we don't like the idea of having very large insurers who've got a lot of business in the UK who are not authorised in the UK, because we think that we don't have sufficient control over what they're doing, and we're not really willing to rely on regulators in EU when we've not anymore got a say in EU legislation. So what the PRA has said is that they will look at the amount of business that's written with retail customers in the UK. And if the business written with UK retail customers, it's a bit more refined than that, but broadly speaking, UK retail customers exceeds total liabilities of £200 million, then they will say that they require option 3, which is establish a subsidiary rather than be allowed to carry on with the branch and just have the branch authorised. And that will make a significant difference because of the two reasons I've given: the need to move capital to support the new subsidiary and the need to do a transfer scheme in order to move the business from the UK branch they had before into the subsidiary. So that threshold is very important as to where we put the line for where somebody is allowed to carry on with their branch as compared to where they have to set up a new subsidiary. Now the PRA is not being absolutely definitive on that and has said it will be flexible. 200 million is the starting point, but if you can convince it that there are good reasons why you should still be able to use the branch, it will listen to that. Nevertheless, it's still quite a significant issue because there are some insurers who have very large amounts of liabilities, and it will be very hard for them to justify trying to avoid option 3. What about UK insurers who are currently operating in the EU? Well, they could try the equivalent of option 1 and get each existing EEA branch authorised, but that would mean 27 or potentially 30 different applications being made for authorisation. And that's a long and laborious task, and probably therefore not such a good idea. In their case, option 3 is better. Establish a new subsidiary in one of the EEA countries, get it authorised. That's an intensive process, but it is one more company to get authorised, and then through that subsidiary passport throughout the EU without requiring any more authorisations. And so really you've limited the amount of authorisations you needed in order to do that, and you've really then carried on passporting as you were before. So we think for UK insurers, option 3 is likely to be better because, and of course that's what we've seen quite a few do. So Lloyd's of London, for example, is doing precisely that, setting up the new subsidiary in Belgium, and then that subsidiary will be free to passport throughout the EEA. Now there is the drawback: you do need to capitalise, and you may still need to do an insurance business transfer scheme in order to move the business into that new entity. However, it may well be worth it rather than doing 30 applications for authorisation. And so we'll come back to these slides, and that's essentially what's going on here. The UK insurer is incentivised to set up the new subsidiary in Germany so that it can passport into France. It would still need, in fact, to get authorised as a branch in the UK in order to do business in the UK if it needed to. But for all the other passporting, all the other business going into other branches, it will actually be in a stable state where it doesn't need to continue to get new authorisations. But lots of things to think about with this kind of thing. What happens to your reinsurance arrangements? What happens as regards transferring the business from one entity to another? And various things like all your finance contracts. And John actually very ably talked about a lot of the different considerations if you start moving your insurance company or your intermediary around. Community co-insurance, you can see, I'll let you read the slide in due course, I won't talk about that. And financial promotions is another difficult area of the law which restricts what you're able to communicate to customers. So you want to advertise your services or say how good your services are, then you're restricted in doing that. But it actually, when people have looked at the UK law on this and how it applies to entities in the EU, if we leave the if we leave the EU, actually leads to some quite peculiar results. So we may well see that this law gets looked at again and has to be corrected. Equivalence, I said I would talk about. There are 4 different types of equivalences under Solvency II. And essentially what this means is that if you're not in the EU, but your country is considered to be equivalent to the EU, then for certain purposes, you'll be treated as though you were a member of the EU. And this is stronger or weaker in different aspects of the EU law. But where it's particularly strong is in relation to reinsurance and group supervision. In the case of reinsurance, if an insurance company wants to benefit from reinsurance provided by a reinsurer in another country outside the EU, then generally speaking, that entity would have to be rated, or it would have to provide collateral. However, if that entity is not rated and doesn't provide collateral, then the reinsurance could not be taken into account. But there's an exception if that country where that reinsurer is equivalent for reinsurance under Solvency II. And so it will be useful to the UK if we are equivalent to the EU for reinsurance, because that will mean that our entities in the UK who are not rated will automatically be allowed to provide reinsurance to entities in the EU who want to rely on them for reinsurance. And similarly, group supervision is a very important one as well, because that means that if you've got a group, say, that consists of a French and a German insurer and a UK insurer, currently there has to be a consolidated calculation done for all 3 of those entities at group level as part of the Solvency II calculations. And you have one regulator which takes responsibility for the whole calculation. Now, if the group is headquartered in the UK, that would probably be the PRA as the lead regulator for the group supervision. However, if the UK is not in the EU anymore, then there's a question, can that still be the PRA, or does that have to be done by one of the regulators in the EU? And the starting point is it has to be a regulator in the EU. But if the UK is equivalent, then that can still be the regulator in the UK, notwithstanding that we're not in the EU. So again, we want that to be equivalent. We want to be equivalent for group supervision, because if we're not, we'll end up with a situation where we have to do group supervision to the PRA and also group supervision to one of the regulators in the EU. So it will be duplication of what is quite an intensive calculation and set of forms, and for usually 2 to 3 months of work for an insurer at the beginning of a year. This is a summary of the equivalence decisions already made under Solvency II. You can see that the 2 that I talked about, which are the most important, the reinsurance, there's Switzerland, Bermuda and Japan, and for group supervision we've got Switzerland and Bermuda. You see that USA is not on either of those at the moment, but that's hoped to be corrected through the US-EU covered agreement. I won't go into that more, except to say that that's a covered agreement that will help EU insurers to do business in the USA, and the UK won't be part of that once we leave. So we will need our own covered agreement with the USA if we want to replicate the benefits of that agreement. But leave it to say that in terms of question, will the UK be equivalent? Well, it's actually quite a narrow group of countries who've currently been decided to be equivalent. That said, if Bermuda's equivalent, then surely the UK must be equivalent as well, because Bermuda doesn't have an exact replica of the EU laws, whereas we, because of the way that I mentioned earlier, are going to crystallise the EU laws into our law. We're going to have an exact copy of the EU laws on the day of Brexit. So if the EU says to us, you're not equivalent, I think we would have quite a good reason to complain. But we could complain, we didn't actually have any legal recourse. If they decide that we're not equivalent, that's entirely within their political discretion. It's not something where we could go to court and say, no, you're wrong, we are equivalent, allow us to be equivalent, please. So falling out with them over the withdrawal agreement could have the consequence that that is used against us in terms of an equivalent decision. Now, I don't think long term they could with a straight face say we're not equivalent, because if we've got exactly the same laws, then we clearly are. But what they might do is delay the decision. They might say, well, we need time to think about it, and in the meantime we go 6 months without being equivalent, which is obviously very harmful when we want to be able to have reinsurance and group supervision working as it does now. Various things about what might be agreed, I think that's been covered very well already today. but the thing I wanted to talk about here, two different voices that are coming through, and John talked about what can we do as an industry, and you're thinking about it from the loss adjuster's perspective. How are we going to make our voice heard? In the case of the insurance industry more generally, and the financial services industry more widely, that voice has already been put forward. There's quite a strong lobbying group putting forward the views of the financial services industry. And there's two approaches coming almost at different ends. What I call the basic minimum approach, contrasted with the keep as much as we can approach. The basic minimum approach deals with the problem that I mentioned right at the start of this talk, which is, will it be legal for an insurer to continue to pay claims on a contract once we leave the EU, if that's a cross-border contract with policyholders in another jurisdiction? So that's one thing. And we've got the bodies like the ABI and the Treasury Select Committee who spotted that problem and said, we have to do something about that. We can't have policyholders not getting paid or having long delays in payment. Now this voice has been listened to, and the UK government, in the UK it's been listened to, and the government has said, if necessary, we'll change the law to make sure this doesn't cause a problem in the UK. As I said, we need something in all of those other EU jurisdictions to make sure it's not a problem there either. But there should be a sufficient political incentive everywhere for that to be fixed, as there is in the UK. What about keep as much as we can approach? Well, we've got three different bodies here who've put a massive amount of work into designing what they think is a Brexit roadmap, or indeed a toolkit. They've used that phrase as well, in terms of working out how are we going to carry on effectively exactly as we are now, with access to the EU market. And they've come up with these different reports saying how they would do it. And it comes up with ideas like mutual recognition. We'll have an agreement with the EU that because our laws are sufficiently similar to theirs, we can carry on passporting exactly as we are now and have all the benefits of membership of the EU, which is great. And I think probably everyone who works in the insurance industry or would say that's a good thing and we should have that. The thing that concerns me about this, because I mean we've been involved, Hogan Lovells is working with the International Regulatory Strategy Group and we're heavily involved in writing their three reports. But the trouble with it is that it all supposes that there is a political will to let things carry on as they are in the insurance industry, and that our industry is sufficiently important that we should be allowed to have that, notwithstanding everything else that's going on with Brexit and notwithstanding the political will that led to us voting for Brexit. And so while this is all very carefully thought through and would work from a legal perspective, we have to consider whether that's something the government is ultimately going to be able to say will be the case, and at the same time tell the UK population that it has delivered something that really is Brexit, rather than letting everything stay the same and putting a rubber stamp on it and saying that's Brexit. And I think that will be, in the end, that will be the main obstacle to getting what we want. It won't be so much being able to persuade people in the EU about a withdrawal agreement or the terms on which we could work together to have a properly functioning financial services market, notwithstanding the UK's outside. The real enemy to this is the ability to have something the government can, with a straight face, say to the UK population, this is Brexit. So we will see. I wanted just to finally talk about what's happened recently. And at the end of December, we had some important communications issued. I've talked already about the 200 million standard. That's what the PRA has announced. Essentially, it will let you have continue to have a branch and have that branch authorised, and thereby avoid the need for new capital coming in and a Part 7 insurance business transfer scheme, provided you've got less than 200 million of retail liabilities. So that's a very good thing. They've also said that to deal with the point I also mentioned about it takes a year to get a new authorisation through, well, they will start accepting authorisation applications from January 2018. So we have clients who are already starting that process of filling in the forms necessary. So that's a very pragmatic approach. The Treasury has said, as I mentioned earlier, it will introduce legislation to deal with the continuity of contracts and letting insurers pay out claims when necessary. It will also, if necessary, introduce a temporary permission regime so that insurers and intermediaries who do not yet have permission by the time of Brexit will automatically be given a temporary permission so they can carry on, which is a very good development, because that means, particularly in the case of insurance intermediaries, where there are literally over 10,000 of them, and they almost certainly can't all get their applications through by March 2019, that they will automatically be allowed to carry on as though they had the authorisation in place already. So very pragmatic approach by the UK government. There's a couple of other statements that have been made there, particularly the FCA statement is relevant to insurance intermediaries. FCA is saying you still need to be working on your contingency plans. Don't stop working on those. However, if you get to Brexit date and we haven't said yes to you yet on your application, don't worry, you'll still be allowed to carry on being an insurance intermediary in the UK. That doesn't fix the problem in the EU though, and when the UK leaves the EU, there will be no ability, no harmonised law among the other EU member states regarding whether or not the intermediary is allowed to do business in those member states. Each member state can decide for itself whether that insurance intermediary is allowed to do business in that member state. And that is also a major issue for intermediaries, because they will have to examine the law in all the countries where they do business to say, well, what do I need to do in order to be allowed to do business there? And they've no as of right ability to expect to be allowed to do business there in the future. So problem is fixed in the UK, but we have to look now to the EU to see how is the EU going to fix this, if it will at all. And for that to work, we need to have good continuing political dialogue. Law is not enough, it has to be political dialogue. Finally, there's one thing I wanted to point out, the Yopo opinion, which was published at the end of December as well. And this goes to the question whether, if an insurer has already written business in the EU prior to Brexit, will it be allowed just to run that business off without getting a new authorisation? And there is some ambiguity about this in Solvency II, in the European insurance legislation. And it was thought until relatively recently by some countries, no you don't. You can carry on running off your business, provided you an authorisation when you wrote it. If you're only just running it off, you don't need a fresh authorisation to do that. And you can in fact have your authorisation taken away and carry on as you were. Yope has now come out and said, no, that's not correct. You do need an authorisation to do runoff. EIOPA is not binding, it's not like a court. EIOPA is just a body that can issue guidelines. However, it's recognised as a significant body in terms of it's a supervisory authority. So somebody who wants to take opposition to the EIOPA opinion will have a very hard uphill struggle. So therefore, that opinion has actually made, although it's provided some level of certainty, it's actually dampened the hopes that some insurers had that they could just stop doing business in the EU and run off their business without worrying about having to get authorised. They won't be able to do that. So that's the end of my talk. Thank you for your patience and for listening. I'm very happy to answer any questions, and thank you.
Thank you.
And I think, are we also going to do a panel or take questions generally? No? Oh.
We will definitely be asking you questions.
Good. Please go ahead.
Questions?
Yes. Yes, go ahead, John.
Just one question, Stephen. Do you know how Lloyds are getting on with their Brussels application? I know they applied, and when it's announced in the press that different companies are moving, you know better than I do that behind the scenes that simply means they have a statement of intent to move, but they then must, along the lines of what you've said, they must go then and apply for their license and so on. Is it public yet, for example, for Lloyds, whether or not they've got their...
No, there's not been any public announcement about how successfully it's going, nor would I expect there to be, because it is a very long process. Yeah. So regulator's got 6 months and it can extend it to a year. Lloyds is a particularly difficult one because Lloyds has an internal model. Solvency II allows insurers to get special permission to use an internal model. The UK and Germany have been the only major jurisdictions which have approved those models. There's a few exceptions to that, but the effect is Lloyds has got the most complicated internal model of anyone in the whole of Europe because it aggregates together the models of every syndicate at Lloyds. So about 50 syndicates at Lloyds, and the Lloyds central internal model is an aggregate of all those 50 with some adjustments made to it. So that's therefore got to go to the Belgian regulator, who's got to look at that and say, oh well, okay then yes, we'll approve you. It's going to be a long process for them to get their head around that. No, by no means not finished. I mean, I think they'll be successful because they've got the resources to throw at it to make it successful, and they'll be able to accommodate whatever the Belgian regulator asks. And I think it's probably seen by the Belgian regulator as a considerable privilege to have Lloyds wanting its subsidiary to be in Belgium. I think they will manage it. They're a very great advantage, although they've got the disadvantage of having the most complicated internal model. They're at a considerable advantage compared to, say, an intermediary who wants to do this, because they've got the vast resources within their legal team, within their general business team, and the Lloyd's market as a whole has got a vested interest in pushing it through as well. So I don't think we'll see them fail.
What are the implications of not triggering a withdrawal from the European Economic Area?
Yeah, it's interesting. Probably nothing much, because our ability to use passporting within the European Economic Area depends upon us being a member of the EU. So it's as though we'll just lose out on the powers that we would have had to passport into those jurisdictions. But I do worry that whenever you get stuck in a contract, which the Eea Agreement is a contract, and you remain a party to it and you didn't validly terminate your obligations under it, then actually there could be some things which come back to haunt you. I mean, I haven't looked into it in detail, but I imagine there are some responsibilities, for example, to contribute to a budget, to take heedance of court decisions of the court. It's not the Court of Justice of the European Union, it's the equivalent court for the EEA, but to take that into account. And currently we're party to a contract that says we'll do that. I think it would be therefore pretty untidy and possibly come back to haunt us if we don't just do it properly and leave. But the people I've spoken to have sort of suggested, oh, well, we won't bother with that. I did wonder, say, 6 months ago when I was told that, whether we were actually hedging our bets, and we didn't serve that notice because we don't need to, because it's a year's notice rather than 2. So we don't have to have served it yet, whether we were leaving open the possibility of remaining in the EEA, and that's why we weren't doing it. But I think the government has now been so clear that we're not doing that. We're not doing the Norway solution, which is what the EEA is, that for them to try and hold on to that isn't realistic. But I personally hope we will serve that notice, because otherwise we do leave things very untidy and potentially regret it.
Stephen, can I ask you something about due diligence by a service provider on a client?
Yes.
If lawyer, forensic scientist, loss adjuster, forensic accountant is contacted by an insurer to deal with a matter under an insurance policy.
Yes.
At the moment, I don't think, apart from unless it's a new client, there might be a small amount of due diligence. No one really starts to ask the question, is the contract that I'm working under legal or not?
Yeah.
How would you see every insurer having to answer that question from a service provider?
Yes, I think there's a number of dimensions there, and exactly how the service provider is helping. If it is providing a service to the insurer, then the insurer can, that bit will not be made illegal. It doesn't necessarily mean that that's a regulated activity that's been provided to the insurer. And if it's just entirely within the same country, there won't be an issue. However, if it was a case, for example, and to take the clearest case, not of a loss adjuster, but of somebody who's selling a policy, an intermediary selling a policy on behalf of an insurer, that could have a very significant effect, because if that intermediary is not validly authorised, then even if the insurer is validly authorised, the contract with the policyholder is invalid and can't be enforced. So looking for all the entities to understand the position of the others is very important. If you were a regulated entity, so if you were a loss adjuster who was regulated to provide services under Intermediate and Insurance Distribution Directive, then doing business with an entity that was itself acting illegally would taint your reputation and could be a reason why the regulator, your own regulator, looks at you and says you should not be doing that. And so I would be asking the question.
In the UK, my understanding is that the insurance companies have regulation responsibility for the loss adjusters that they pay. So there's no obligation unless we act for policyholder to be FCA.
Yes,
regulated.
Agreed.
So you have technically non-regulated loss adjusting individuals and companies dealing with a claim, an adjustment of a claim, on a policy that could possibly, for some reason, not be legal.
Yes, and I suppose if you look at if you try to apply the criminal law to that, what you've got is a situation where you are assisting in something that is a criminal offence. Now that's a very extreme way to look at it, and particularly as the UK government has said, we will fix this problem to make it legal to pay out. But taken as a most strict application, yes, I mean it is a criminal offence for the insurer to do it, and anyone who knowingly assists in a criminal offence is thereby also committing a criminal offence. So you'd be right to ask the question. I hope that you won't end up in police station as a result, but it's worth bearing in mind. Yeah, well, I think if it comes to, yeah, exactly. I think if it comes to the stage where you're calling a lawyer because of that, then there'll be so many problems across there'll be business for lawyers forever. Yeah. I realise it was quite a technical legal point, but I realise the practical side has been well covered already today, so I hope you don't mind at this stage having all the technical side as well.